here to talk to you today about a recent protective order hearing victory we had here in Marion County. In Indiana, someone can file for a protective order for a variety of reasons. And it's not a criminal matter. It doesn't require the police having to come out, doesn't require police reports or criminal charges. Protective order is something that is civil in nature, even though it kind of seems a little bit criminal. Now, in order to file for a protective order, you have to do it in the county that you live in. But basically, if you believe that you are the victim of domestic violence or repeated acts of stalking or harassment, you can file a protective order in the state of Indiana against someone. Now, while it's not criminal and a protective order isn't going to amount to jail time if it's granted, there's a lot of negative consequences that can come with a protective order. The number one being that a protective order is, in essence, you cannot go towards that person, you cannot speak with them, you can't communicate on the phone, Facebook, text, emails. You can't do anything if there's a protective order in place. And many people might say, hey, I don't want to talk to that person anyways. A lot of times where it becomes trouble is if you have children with that person. If someone files for a protective order and it's granted and they have your children, you're not only going to be prohibited from going and talking to that person, but if the children live there as well, you're not going to be able to see your children as well. Another negative consequence that comes with the protective order is you lose your rights to own firearms. So even though you're not charged with anything criminally, if you have a protective order granted against you, you will not be able to carry or possess firearms and ammunition anywhere in the state of Indiana. So like I said, anyone can file a protective order against someone in the state of Indiana, but there's also another caveat. If the person is a minor, a parent can also file a protective order for that child on their behalf. And that's exactly what happened this week with us. We had a client who was getting a divorce from his wife, and they shared a child in common. This wife then filed a protective order against the father for her son. She was alleging that there was violence committed by the dad against the son and wanted the court to grant a protective order preventing our client from having any contact with his son. Now, protective orders are somewhat of like a trial. You go in front of a judge, and whoever filed that protective order then has to present their case in front of the judge to convince that judge that the protective order should be granted. And in this particular case, this means that the son would have had to come and testify against his father in order to get this protective order granted. Now, luckily for us, the son did not show up. And that means that the mom, on her own, had to convince this judge to grant the protective order for her son. But she didn't see anything. She only heard things from other people, not her son. She never saw any acts of violence. This was all things that she heard from other people. So when it came down to the trial, she wasn't able to establish anything showing that our client actually harmed his son, because he didn't. But at the end of the day, the judge dismissed the protective order because there was no evidence showing that our client had anything to do with any sort of harm coming to his child. And what that means for our client is, one, he gets to continue to see his son that he loves. He's not going to be prevented from seeing him, calling him, texting him. And for two, he doesn't have to lose his rights to a firearms, which for our client was a very, very, very big deal. If you're facing a protective order or would like to file a protective order against someone, we are happy and here to help. Please give us at Marc Lopez Law Firm a phone call, 317-632-3642. And always remember, plead the fifth.